Streaming. Shall we start? Good afternoon. What was our earlier discussion, ma? Independence Day celebrations. Independent director. So, what are all the topics we have covered in yesterday's session? Independent director completed, nominee director completed, and then only two topics completed. Casual vacancy director, additional director, alternate director, nothing. Okay. So, I think yesterday night, if I'm not wrong, someone asked PDF of directors and KMP chapter, and I have shared the same in your group only, right? Everyone got the PDF, right? Okay. So use the PDF for reference purpose only. Okay. So don't study it in advanced way. Why? Because you understand nothing. So after explanation, you please refer for reference purpose only. It will be useful. Okay. Don't try to cover advanced portions. Sir, I wish to cover on advanced way, sir. I'm a diabetic patient. Okay, then it is your wish. So nominee director completed. Nominee director is appointed by, simply nominee director is not appointed by board of directors or not appointed by shareholders. Nominee director is a person who gets appointed or who gets nominated by someone else. Generally that someone else may be bank or financial institution or government according to the law or agreement. Okay. So seventh one we need to discuss, right? Alternate director. Seventh one what ma? Alternate director. So before this, 5 independent director completed, whole time director completed. MD, executive, non-executive. Yes, very good. So alternative director. Let's discuss who is a alternative director. Alternative director. So alternative director is a temporary director. Who is alternative director, ma? Alternative director is a temporary director who will take charge in place of original director. Say for example, one company is there, X Limited. For this company, Mr. A is acting as a director. Mr. A is acting as a director. Now, due to personal reason or professional reason, whatever the reason may be, Mr. A is going out of India for a period not less than 3 months. Say for example, Mr. A is going out of India for 1 month vacation, or 2 months vacation, or 2.5 months, nothing gonna happen. But if it is confirmed that Mr. A is going out of India and the stay out of India is more than 3 months, that means not less than 3 months. So then in place of Mr. A, company needs to appoint someone, X or Y or Z, whoever it may be. Okay, so alternative director is a temporary director who will take the charge if the original director is going out of India for a period not less than 3 months. This is the rule. And why we are calling this alternative director as a temporary director means as and when the original director came back to India. That means as and when the original director returns, obviously and automatically this alternative director is going to vacate the office. Why? Because at a time simultaneously two persons acting as a directors. Okay, but original director is going out of India. That is why powers has been allocated or delegated or transferred to alternate director. But now original director came back to India. Then what is the role of alternate director? No role. That is why alternative director will immediately vacate his office just after the return of original director to India. That is why we are calling him as a temporary director. Which director? Temporary director. So what is the significant point in this concept is period of stay. Only that point is important and relevant from examination point of view. They may frame an MCQ on this time period and all. How much is the time period, ma? How much is the time period? Minimum 3 months. So the stay should be more than 3 months. Then only there is a significance for appointment of alternative director. And what is the tenure of alternative director? What is the tenure of alternative director? As and when the original director came back to India, obviously alternative director will vacate the office. This is one point. And another point is the powers of alternative director is equivalent to the powers of original director. Whatever the acts original director is supposed to do, all those acts can be executed by this alternative director also. But beyond that powers, alternative director also not possible to exercise. Okay, so the powers of original director is equivalent to the powers of alternative director. Okay, so let's read out alternative director, a director appointed to act in place of director who is absent from India for at least 3 months. For at least 3 months. And the conditions are alternative director can be appointed if authorized by AOA or resolution and cannot be appointed for independent director unless qualified. It means whatever the qualifications, whatever the qualities we have discussed yesterday relating to the qualities of independent director, the alternative director must also possess the same qualities. Then only substitution will be possible. Otherwise, say for example, we appointed independent director for company ma. He is a person of integrity. He is a honest person. He is well qualified and well experienced. So all the qualities suggested by Companies Act possessed by the so-called person, independent director. Now this independent director is going out of India for a period of 4 months. For a period of 4 months. Now we are planning to appoint one of our whole-time director as alternative director to the independent director. Tell me, is it possible? Tell me, is it possible? No. Why? Why? Because from independent director, what you are expecting? Unbiased decisions and protecting interests of the company and shareholders. These are the things which you are expecting from independent director. Then how this WTD is going to act? WTD means how this whole time director is going to act? Can you expect independence and unbiased decisions from WTD? No. That is why if you wish to appoint an alternative director to the independent director, yes, you can appoint, but make sure that the alternative guy is also well qualified as the independent director. Without qualification, you can't appoint. That is what the provision is saying. Is it clear? So, to any place or for any position, you may appoint alternate director, provided if the director is going out of India for a period not less than 3 months. That is the point. And last point is, I have already told this point. What is this point? Alternative director automatically vacates the office when the original director is returned to India. Few students will ask, sir, what if again he is going out of India? Again, the same person will be acting as alternative director. Say for example, what is this month, ma? Augusta? Don't you know the name of this month? August 25. August 25, one of our director is going out of India for 4 months. For how many months? 4 months. 4 months means we have to appoint someone in the place of the original director, and the so-called temporary person will be called as alternate director. So August he went, and January 26 is planning to coming back to India. And actually, February 12th, 2026, he came back to India. February 12, 2026, he came back to India. So, alternative director position will be, that means the office of alternative director will automatically be vacated on which date? February 12, 2026. Why? Because August he is going out of India. At the time of August, his plan was to coming back to India January 26. That is January date. Say for example, 12th January he said. So expected date of arrival you can't take. Expected date of arrival you can't take. The actual date of coming back to India you need to consider, and on that arrival, on that date, automatically the office of the alternative director will be vacated. That is, we need to consider the actual coming back date. Okay, that is okay. Now, February 12th, he came back to India, and March 1st, again he is going out of India for a period of 5 months. 1st March 2026, again he is going out of India for a period of 5 months. Now tell me the situation. Again, the same person will be automatically appointed as an alternative director to the position of original director, or you need to appoint someone else again? Tell me what you are thinking, sir. Recently, up to 12th February, say for example, we appointed Mr. Yes. We appointed Mr. Yes in the place of original director as alternate director. And yes position, yes office will automatically be vacated on which date, ma? 12th February 2026. Why? What happened on 12th February 2026? Nothing happened, sir. Original director returned to India, sir. That is why automatically no need to pass any board resolution and no need to take any approval from alternative director, ma. Office of the alternative director will automatically appointed. No need to take anyone's approval. As and when the original director came back to India, automatically alternate director has to vacate the office. There is no option. That is why we are calling him as a temporary director. Temporary director. Now tell me. So 12th February he came back to India. 12th February he came back to India. Obviously, Mr. S is going to vacate the office. Yes, he vacated the office. Very good. Now again, 1st March 2026, on an unexpected plan, the original director is going out of India for a period of 5 months. Now tell me, what company has to do? Company has to appoint again only Mr. Yes as alternative director. Question number 1. Question number 2. Sir, no need to appoint again on a fresh note, sir. Being Mr. S of February 26 means leap year, amma? No, not a leap year. So February 12, February 28 days. Just 16 days passed, sir. Just before 16 days also, Mr. S is used to act as additional director to the original director, sir. So obviously and automatically, Mr. S is going to take the position of original director, sir. So is this contention valid? I have asked 2 questions. Question number 1. Question number 1. Is there is a necessity on part of the company to appoint additional director again? Question number 1. If yes, sir, there is a need to appoint additional director, sir. If yes, then who will act as alternative director? Whether yes automatically or any other person? Answer these 2 questions. First question. Is there is a necessity on the part of the company to appoint alternative director to the position of original director? Tell me, is there is a necessity or not? Yes or no? Why yes? Why? Because, sir, original director is going out of India for a period of how many months? 5 months. What rule is saying? If director is not available in India for a period of more than 3 months, then what company is supposed to do? Company is supposed to appoint someone else in the place of original director. That someone else will be called as alternative director, and the tenure of that alternative director will automatically close as and when the original director came back to India. This is what rule is saying. That is why, being this person is going out of India for a period of 5 months, obviously there is a necessity on part of the company to appoint alternative director to the position of original director. This is answer for first question. Question number 1. I have asked another question. Who has to act as alternative director in the place of original director? Mr. S or any other person? Mr. S or any other person? Why I am specifically asking this question means, few students will be in a confusion state saying that yes, as and when original director returns, obviously alternative director will vacate the office, and as and when the original director came back to foreign country, automatically the appointment will be carried on with the company. Few students will be think like this. That is why I am again saying that this is not an automatic appointment or automatic reappointment. It will always depends on case to case. Say for example, in previous case we appointed Mr. S as alternative director to the original director, and yes, served to the organization, the so-called company, and as and when the original director came back to India, yes, vacated the office. There ends the matter and there ends the contract. There ends the contract. Again, there is no relation between Mr. S and original director. Highlight this point. Okay, so Mr. S is not a permanent alternative director for the original director. Don't think like this. As and when the original director went to foreign country, automatically Mr. S will come in the place of alternative director. No. Alternative director appointment is a one-time job, not a recurring job or a routine job or a regular job. Say for example, in the place of Mr. ఏం పేరమ్మ నీ పేరు? హేమ. Mr. Hema. Hema. Miss Hema. Or I should delete. Hema. Okay. In place of Hema, we appointing, what's your name? Chandana. So Hema is going out of country for a period of 4 months. Now Chandana is acting as alternative director for the position of alternative director in the place of original director Hema. This is how the process is going on. She went to abroad for 4 months and works completed, again came back to India. Now what's your position? What's your position? She came back to India. So you will automatically vacate the office of alternative directorship. This is point 1. Point number 2 is, again Hema is going out of India for a period of 5 months. Now tell me, is your appointment again automatic or someone has to appoint you as a alternative director? Again, if company specifically appoint you as alternative director in the position of original director, then only you have to act as a alternative director to the company. Say for example, second time she went to abroad and company didn't approach you for the position of alternative director, and some manipulation or deviation or some contravention happened with the administration of the company. Are you going to liable for the activity? No, you are not liable. Why? Because you are not having any sort of active relation with the company as of now. అదేంటి యు ఆర్ ఆల్టర్నేటివ్ డైరెక్టర్గా? అదంతా అప్పుడండి, ఇప్పుడు అవన్నీ లేవండి, మారిపోతుంది. సో యూ హ్యావ్ సర్వ్డ్ యాజ్ ఎ ఆల్టర్నేటివ్ డైరెక్టర్ ఇన్ ఏ ప్రీవియస్ కేస్. So your appointment roles, responsibilities, duties, whatever activities there, they're automatically finished as and when she came back to India. Okay, so don't think that alternative directorship is a recurring job or a routine job or a what we say, as and when the original director came out of, as and when the original director went out of India, automatically this alternative director will occupy the position of original director. Don't think like that. Why? Because it depends upon case to case. As and when company appoints specifically some person as a alternative director in the position of original director, then only alternative director will get the powers. Otherwise, no powers. Otherwise, no powers. Okay. So this thing you have to remember. So again, read this point, ma. Who is alternative director? Alternative director is a director appointed to act in the place of a director who is absent from India for at least 3 months. Sir, director is not going anywhere, sir. He is in India only. He is in India only. Is there a necessity on the part of the company to appoint any person in the name of alternative director? No. Why? Because he is staying in India only. So why to appoint additional director? Oh, sorry. Why to appoint alternate director? Okay, that is the thing. And conditions are authorized by articles or resolution cannot be appointed for independent director unless qualified. That means if the alternative person is also a qualified person, yes, in the place of independent director, you can appoint that so-called qualified person as alternate director. And the third point is automatic vacation. No need to take anyone's approval, BOD approval, CG approval, nothing. As and when the original director returns, the position of alternative director automatically vacated. This is the concept of alternative director. Next, additional director. Next is what, ma? Additional director. So additional director is very simple. Why the company will appoint additional director? Means, say for example, workload on the company is very huge. Company is going for expansion and creamy layer of directors are completely involved and indulged in the merger activities or expansion activities or any other strategical decision activities. They are completely occupied. They don't have the time to invest for regular activities. You know about executive director, right? Executive directors are those directors who will take active part in the day-to-day activities. Now, these executive directors are completely involved in the expansion activities. They have to take strategic decisions like merging activity or any other takeover activities or expansion relating to expansion is not a simple thing. You have to license bankers, so-called prospective buyers. Say for example, company is going for IPO. It is a very hectic job. Why? Because you have to balance merchant bankers, you have to balance SEBI rules and regulations, underwriting activity, and you have to look after promotional activity. Why? Because no one will subscribe your shares. You have to indulge in those activities and all. So main layer of directors are completely occupied in this kind of strategic activities. No one is there to invest time for the day-to-day activities. Now someone should be there to look after the day-to-day activities. Then you may appoint additional director. In simple, what we can say, sir, if the workload on the existing BOD, board of directors, is so huge, then in order to discharge that workload, BOD may appoint additional director. And mind you, appointment of additional director is completely done by BOD only, not by shareholders in the general meeting. Usually, directors are appointed by shareholders in general meeting. That is one of the main job, right? Tell me the 4 jobs. Adoption of financial statements, declaration of dividend, appointment or reappointment of auditors, appointment or reappointment of board of directors. These are the regular activities. So out of that 4 regular activities, one of the activities there no appointment or reappointment of directors, the board of directors. So usually board of directors will be appointed by shareholders, but additional director will be appointed solely by BOD Depends upon the case to case. Say for example, workload is very small or very minute. There is no work for board of directors. There is no work for board of directors. Now, board of directors will appoint additional director. What is the necessity of additional directors if there is no work for original directors also? No. If the workload is very high or very huge, or BOD has to devote the time for strategic thinking or strategic decisions and all, then in order to discharge the regular workloads and all, these board of directors will recruit some persons, that some persons will be called as additional directors. And one more thing is also there. What is that one more thing is? Say for example, you started OPC, one person company, or you just started a private company, ma. Which company? Private company. Or OPC, whatever it may be. You started OPC or private company. You have very noble thoughts with respect to execution of business. Your thinking level is very high and you are about to do the business in a large scale. Very good. But you are very new to the business. You have to employ those persons who are actually doing this business or who know the dynamics of the business. Say for example, Mr. X is there. Mr. X is acting as a director of a big public company and he is drawing 10 lakhs per month as salary. 10 lakhs per month as salary. Okay. Or another example, say for example, you know Zoho. Zoho company, everybody know what Zoho will do. Huh? Accounting software. Okay, very good. At least somebody know. Like SAP or Tally at the initial stages and all. Listen, they are offering bookkeeping services. Say for example, in order to discharge these bookkeeping services, company has to employ accountants. At least 2 to 3 accountants they will need. At least you have to pay 20,000 per month as a salary. 20,000 into 20, how much? 40,000. That means in order to, by spending 40,000 per month on payroll, on accountant's salary and all, please pay 5,000 for us. Zoho company is asking like this, please pay 5,000 for us. We will discharge all the bookkeeping activities. We will take care of the activities. In this way, you can save 35,000 per month as salary. By taking the company Zoho as inspiration or Tally as inspiration, you wish to start a company. That company will offer this kind of bookkeeping activities or financial. Recently, Geo Financial Services also launched filing of income tax returns at 20 rupees, 27, 24, somewhat 24 rupee or 25 rupee. Okay, do you think the profession is going to be affected by offering such services at a meager prices? Yes, sir. Whoever saying yes, they don't have full picture regarding the profession. Man, no accountant or no chartered accountant or no cost accountant is drawing their livelihood by depending upon income tax returns. That is a very insignificant job. It is a separate dimension discussion. I'll discuss at a later point of time. Forget about that Geo's financial services. Say for example, you wish to start a startup or OPC or a private company, a small company, which offers bookkeeping services and all. But you are in talking terms with a software company and the software company has to develop a software which suits small scale businesses or large scale businesses or medium scale businesses. Whenever they gave input, proper input, the output should be readily available. You are customizing that kind of software by entering into a contract or agreement with a software company. Now, two players are there in business. One, a small company which is incorporated by you, either a OPC or a private company, and that small company entered into an agreement with a software company. What this software company and small company are doing? This private company started by you is going to give the ideas or what are the directions for the software company, and depending upon the directions or inputs given by the so-called OPC or private company, software companies creating or designing a software for small companies, medium companies and large companies, and the software is designed in such a way that the software is offering, that means the OPC or private company, you are offering services to all small companies or medium companies or large companies, saying that if you give proper input, we will design all the financial statements and all. No need to draw any financial statements or any trading account, P&L account, balance sheet, cash flow statement on your own. If you give proper input in backend, we are going to design everything for you, and for that we are charging 5,000 per month. Likewise, you are going to offer subscription model services for all the small companies, medium companies and large companies. So what is your ultimate aim creation of this software? Currently, you just started a OPC or a private company. Your idea is not completely implemented. As of now, no one is there for you to believe in your idea. Why? Because your product is not ready yet. Maybe after completion of the product and launching of the product, maybe few investors may come and invest in your company. Maybe your idea may be after implementation, maybe your idea may become successful. That is a different dimension. What I am trying to teach is, you started a OPC company or a private company, one small company you started, and you have entered into an agreement with a software company. Very good. Your ultimate idea is to develop this kind of ERP, enterprise resource planning. This is your ultimate idea. Now, in order to cope up with software company, one experienced person should be there, right? What kind of experience he should possess? Sir, that experienced person should give clear cut instructions to the software company for the development of software. Why? Because my software should be bug proof. There should be no errors in my software. That is why I have to hire an experienced person to my company. Why? Because what is the job of that experienced person? He has to cope up with the software company, and he has to give ideas to the software company, saying that you should do like this if it happens, you should do like this if it, that means case based scenarios we are talking about. If it happens like this, you have to do like this. If it happens like this, you have to do like this. So a fresher don't know all about these things. Why? Because he won't be having that much work experience and all. That means you have to hire an experienced fellow. Say for example, one chartered accountant is there. He is into practice from last 25 years. He is into practice from last 25 years. He might be having multi-dimensional exposure with related to bookkeeping and issue solving and all, right? He's going to have much experience than you. Now you started a private company. If you offer employment to this chartered accountant saying that, sir, I'll give you 2 lakhs per month as salary, sir, are you going to accept my employment offer? What would be the reply of that so-called chartered accountant which practicing from last 25 years? Well, if a chartered accountant is practicing from past 25 years, 2 lakhs per month is nothing, equivalent to peanuts. Say for example, he is somewhere earning 10 lakhs per month, minimum to minimum. How much you are offering? 2 lakhs per month. That is, again, that to employment. In order to join with your company, what he has to do on a first note, he has to stop the practice. Is he going to accept your employment offer? Obviously no. Then what you are supposed to do means, case number 1, you have to avail the expertise or experience and knowledge possessed by the so-called chartered accountant. And that's case number 2, that chartered accountant is not going to accept your employment offer. Then what you are supposed to do means, you started a company, right? Private company or OPC, you started a company, right? Offer directorship. Offer what? Directorship. Then he is going to accept. Why? Because in order to be acting as a director, directorship means not an employment ma. Okay, so in order to act as a director, it should be no conflict or no resemblance with the so-called practice. Why? Because practicing chartered accountants are allowed to act as directors also. Why? Because directorship is not employment. Sir, I am acting as an executive director, sir. That is a different thing. MD, whole time director, that is a different thing. You should not accept that kind of assignments. But you are acting as an additional director. You are acting as a additional director. It is not inconvenience or deviating with the provisions of practicing rules and all. That is why this chartered accountant, there are high chances that this chartered accountant may accept your alternative directorship proposal. What you have offered in the first phase, you offered employment. Even though you offered employment at 12 lakhs per annum, that chartered accountant is not going to accept. Why? Because say for example your employment will be in this year ma. Is there any guarantee that you are going to pay 12 lakhs per month for coming year also? Why? Because you are a startup, right? Your company is a OPC or private company, very small company. Your age of the company is very less. What kind of experience you are possessing? What kind of idea you are having? Maybe what if happen if your idea in at the stage of implementation stage, what if your idea becomes a disaster? Obviously he is going to lose the employment. So that is why, on a safe note, no chartered accountant or no practicing cost accountant or any other person who is engaged into practice and all, they are not going to jump into employment offer, even though if you offer 20% or 30% extra. He is earning 10 lakhs ma, you are offering 20% extra. 20% extra means 12 lakhs per annum you are offering, 12 lakhs per month you are offering. No one is going to accept your employment proposal. Sir, then what to do, sir? I wish to utilize the expertise possessed by the so-called chartered accountants, sir. What to do? There is another route. That another route is called as directorship. You have offered employment. Don't offer employment. Offer directorship. Sir, what kind of directorship I should offer, sir? You can offer additional directorship. Then what will happen? There is no objection with his practice. On one hand, his practice will be smoothly carried out, and another hand, he will be available with your company as a additional director. And you can utilize the expertise or experience possessed by the so-called chartered accountant. This is how things are unfold. Clear? So why companies will hire additional directors means, first point, in order to discharge the huge workload, if any, if workload is huge, then in order to discharge the workload, directors may appoint additional directors. Point number 1. Point number 2, if the existing directors are completely involved in other activities and they don't have time to execute the day-to-day activities, then also additional directors will be recruited for the company to discharge the day-to-day activities. And point number 3, if you wish to utilize the expertise or experience of reputed persons, and those kind of reputed persons will not accept your employment terms. So in order to bypass this employment route, another route is there. That route is offering directorship, and companies can recruit that kind of reputed and experienced person for the position of additional directorships. That is why additional directorship appointment is completely in the hands of board of directors, not in the hands of shareholders. Who has the power to recruit additional director? Board of directors only. That means which resolution is required? Board resolution is required. Ma, I have to say this thing. Say for example, general meeting is going on. Forget about AGM or EGM. Anything is general meeting, no? How many resolutions will be there in general meeting? Ordinary resolution, special resolution. Antena? Only two resolutions. Board resolution. Board resolution general meeting lo endukunటుంది? It is there in board meeting, no? Tell me. Ordinary resolution, special resolution. Antena? Only two resolutions. You are conveniently forgetting another resolution. Unanimous resolution. Don't you know about unanimous resolution? There are certain cases where unanimous resolution is required for the administration of the company. That is not there in your curriculum, but unanimous resolutions also there. You know very well about what is ordinary resolution. Votes casted in favor, votes casted against. You have to calculate these votes, and votes casted in favor must be greater than votes cast against the resolution. Then O are said to be passed. Special resolution means more than 3x. Unanimous resolution means 100% agreement. 100% agreement. This is related to general meeting. Now, say for example, board meeting is happening. Board of directors are carrying on with their board meeting. Tell me, how many resolutions will be there in board meeting? How many board resolutions will be there in board meetings? How many resolutions will be there? Have you ever read something about ordinary resolution in board meeting? Special resolution in board meeting? There is only one resolution. There is only one resolution. Low power mode. There is only one resolution in case of board meeting, that is board resolution. BR. There is no concept of ordinary resolution, special resolution in case of board meetings. There is only one resolution. Whether they agreed or not, that is enough. If the majority of the board of directors are in agreement, then board resolution said to be passed. That means, say for example, 10 directors are there. 6 directors are in agreement. Agreement means agreeing to do the same. 4 members are in disagreement. Board resolution said to be passed. So in case of board resolution, in case of board meetings, there is only one resolution, that is board resolution. There is no concept of ordinary, special, unanimous in case of which meetings? Board meetings. Okay. So why I am talking about board meetings? Why? Because additional director will be appointed in, not in. That means additional director will be appointed by passing which resolution? Special resolution or ordinary resolution or special resolution? Sir, there is no bifurcation or there is no classification in case of board meeting, sir. There is only one resolution in case of board meeting, sir. That resolution is very good, board resolution. Read this. We'll read this point. Additional directors are appointed by board between two AGMs if AOA permits them. Obviously, AOA should permit. Okay. ఛార్జింగ్ పెట్టమన్నాను సార్, మర్చిపోయినట్టున్నారు. ట్యాబ్ది 9% ఉంది. ఇందాక ఏమో ఇది కనెక్ట్ చేశారు కానీ వర్క్ అవ్వట్లేదు అనుకుంటా. ఓకే. సో వాట్ వీఆర్ డిస్కసింగ్? Additional director. Key points. First one, holds office only up to the next AGM or last date on which AGM should have been held. So the tenure of additional director is up to only conclusion of AGM. Say for example, today we appointed additional director. దీనికి కనెక్ట్ చేసేద్దామా? Switch on loan. So today we appointed additional director. Today August 23rd, 22nd, 22nd of August we appointed additional director to our company. And our AGM date as per calculation, our AGM date is next year 2026 October 1st. 2026 October 1st. So the tenure of the additional director is 1st October 2026 or on the date which we are actually holding AGM, whichever is earlier. Say for example, we are actually holding our annual general meeting on 3rd September 2026 only. That means 1st October or 3rd September, whichever is earlier. Whichever is earlier, which is earlier, ma? Obviously 3rd September is earlier. That is why on the date additional director will set to be automatically vacated his office. Sir, how to extend the services of additional director, sir? Again you can appoint. Sir, like this, how many times we can reappoint, sir? N number of times you can reappoint. There is no concept of cooling period or maximum appointment tenure and all. Each and every year you have to rotate the same and same and same. This is the tenure of additional director. What is the tenure of alternative director? There is no fixed tenure for alternative director, ma. As and when the original director returns, obviously this guy has to vacate the office. Sir, original director died in foreign, sir. Original director died in foreign country. Then what will happen? Obviously this guy also has to vacate the office, ma. Why? Because he's like a derivative. He's like a derivative. He is drawing his powers from original director. If original director vacates or original director resigns or if original director dies, obviously this guy also has to vacate the office. Why? Because alternative director is deriving his powers from the position of original director. That is why if original director resigns from the office or resign from the company, obviously alternative director will also has to vacate the office. That is the tenure of original, additional alternative director. So when it comes to the tenure of additional director, what is the tenure? Up to next AGM. Sir, AGM is not going to held, sir. Even though you are not actually holding the AGM, as per rules and calculation, there should be a last date to conduct the AGM, right? That day is the last day for the position of additional director. Okay, so next AGM or last date on which AGM should have been held. Next point, board must have authorization in articles of association for such appointment. For everything, AOA should authorize, ma. That is a different thing. Why? Because you might have learned about MOA and AOA. MOA talks about what to do. AOA talks about how to do. How the things needs to be executed and all. It should be mentioned in AOA only. Sir, I don't know how to draw or how to prepare MOA and AOA, sir. Nothing, no problem. You can adopt the same tables that are there in Companies Act 2013. Okay, so accordingly they will decide. So we have completed two discussions, ma. Alternative director discussion, additional director discussion. Once again, tell me the tenure of alternative director. There is no fixed tenure. As and when original director returns, alternative director has to vacate the office. This is point number 1. Tell me the tenure of additional director. Till the next AGM or the last date of AGM which the company would have held. That is the date. In these two dates, whichever is earlier, that day additional director has to vacate the office. Next, casual vacancy director. Very simple. First of all, before understanding CVD, you have to understand what is casual vacancy. Casual vacancy is a vacancy. Casual vacancy Casual vacancy is a vacancy. Listen, we will call vacancy as a casual vacancy only if the so-called vacancy, say for example, one director is there, ma. This director is appointed by BOD. This director is appointed by BOD for 1 year. For how much time? 1 year. For 1 year. After 2 months, this director is going to resign. This director is going to take exit from the company by resignation, or director dies, or company only removed this director, whatever the case may be. So, being the director is appointed by BOD and the director is going out of the company by simply serving the resignation to the company, this kind of vacancy will not be called as casual vacancy. This kind of vacancy is not casual vacancy. Why? Because director has been appointed by board of directors. We will call a vacancy as casual vacancy only if the so-called director is appointed by shareholders in the general meeting. Shareholders in the general meeting. Say for example, XYZ Limited is there. To this XYZ Limited, Mr. X, Mr. Y, Mr. Z are the directors. All these three persons appointment, X appointment, Y appointment, Z appointment done by the members in general meeting. All these three members appointment done by whom? Members in the, members means shareholders only, members in the general meeting. And after 2 months, workload becomes very heavy and XYZ are unable to discharge the workload, and XYZ recruited A and B, 2 persons as additional directors. Additional directors. So, to this company, how many directors are there now? 5 directors. A, B, X, Y, Z. Who are AB? AB are additional directors. Who are XYZ? XYZ are the regular directors appointed by the members in the general meeting. Members in the general meeting. Now, due to ill health or due to old age, Mr. Y is going to vacate his office by simply serving a resignation. He is going out of the company. He is going out of the company. Who is going out of the company? Mr. Y. Why? Old age reasons. He is resigning from the company and vacating his office. Now, this vacancy will be called as casual vacancy. Just after the resignation served by Mr. Y, after 2 days, Mr. A also served his resignation and going out of the company. Now, vacancy caused to the place of Mr. A, will that vacancy will be called as casual vacancy? Why? Why? Because Mr. A deriving his powers or appointment power or appointment work has been executed by BOD, not by shareholders in the general meeting. So, we will call a vacancy as casual vacancy only if the director is appointed by, if the director who is taking exit from the company, if the director is appointed by members, then only that kind of vacancy will be called as casual vacancy. Otherwise, it is a normal vacancy only, and who will get the powers to fill the normal vacancy is BOD. BOD only. Board of directors will fill the normal vacancy. Sir, if it is a casual vacancy, if it is a casual vacancy, then go and read AOA. Go and read AOA. What is AOA? Articles of Association. If Articles of Association permits BOD to fill the casual vacancy, yes, now only BOD will get the power to fill the casual vacancy. Say for example, by serving resignation, Mr. Y went out of the company. Now, BOD can't directly and blindly fill the position of Mr. Y. Mr. X and Z has to read the AOA first. Are we having the powers to fill the casual vacancy? Go and read AOA. What AOA is saying? Go and read it. Yes, AOA is permitting us means BOD. AOA is permitting existing board of directors to fill the casual vacancy. Then we can fill the casual vacancy. No need to call for general meeting and all. By simply filtering the profiles and all, we can fill the casual vacancy. Sir, AOA is not allowing us to fill the casual vacancy, sir. Then you have to call for general meeting. You have to call for general meeting. Members will come and members will elect and members will appoint directors to the company. So what is casual vacancy? What is not a casual vacancy? Do you really understand? Casual vacancy is a vacancy in the position of director if the director gets appointment of the director is appointed by shareholders in the general meeting. That means if the director appointed by members is going out of the company, then that kind of vacancy, then the vacancy created by the outgoing director will be called as casual vacancy. If the director is going out of the company, the director has been appointed by the board of directors, that kind of vacancy will not be called as casual vacancy. Okay, very important. On a prima facie basis, these rules are AOA rules, casual vacancy filing rules are applicable for public companies only. If private company wishes to accept these rules on a voluntary basis, then they can adopt these rules also. Okay, sir, adopting these rules means, say for example, I'll tell you one thing. What I have said, if there is a casual vacancy in the company, that vacancy can't be filed by board of directors in a blind way. They have to refer what? AOA. If AOA gives the powers to board of directors to fill the casual vacancy, then only they are allowed to fill. This is what I am saying now. But what happens in case of private companies and one-person companies or any other companies means, if casual vacancy happen, existing BOD can fill the vacancy. No need to refer AOA and all. This is the point. Sir, I have a private company, sir. I wish to implement strict and stringent rules in my private company, sir. I will adopt the same mechanism which is adopted by public company, sir. I won't give the refilling powers to board of directors, sir. As and when casual vacancy occurs, they have to call for us for the general meeting, and sir, I will strictly implement these rules, sir. Okay, it's your headache. Go and implement the same strict and stringent rules with your company. No one is stopping you. So it is at the discretionary powers of the private company and all whether to implement these powers or not. But prima facie, these rules are applicable to only public companies. This is very important. Okay. So from first point we'll study. So casual vacancy director. So first of all, what is a casual vacancy? A casual vacancy arises when the office of a director becomes vacant before the expiry of his term due to reasons like death, resignation, disqualification, incapacity, removal by tribunal, or any other unforeseen reasons. By whatsoever reason, director is going out of the company even before his term is expired. Even before his term is expired. That kind of vacancy will be called as casual vacancy. Okay. Next, legal provision. If the office of any director appointed by company in general meeting is vacated before his term expires, the BOD may appoint another person in his place. This is what section 161 subsection 4 is saying. Okay. Next, in this table, you will clearly understand applicability only to public companies. Director must be one who was originally appointed in a general meeting. Who is the appointing authority? Board of directors. Tenure of new directors holds office only up to the date of the original director would have been held office if the vacancy had not occurred. I have given the example here. Suppose Mr. A appointed as a director in a public company in the AGM for 5 years. After 2 years, he resigns. Out of 5, how much time consumed? 2. What is the pending time? If you appoint any fresh person in the place of Mr. A, he will be there in that position only up to remaining 3 years. That is what this point is saying. He will hold office only up to the date the original director would have held the office if the vacancy had not occurred. If the vacancy has not occurred, how much pending time is there? How much leftover portion is there for the original director? That for that leftover portion only, we are appointing this new director in the place of casual vacancy. That is why example goes like this. A appointed for 5 years. After 2 years, he resigns. The board may fill the casual vacancy by appointing Mr. B, and Mr. B will hold the office only for the remaining 3 years. Why remaining 3 years only? Why? Because only leftover portion is only up to 3 years. For that remaining 3 years only, Mr. B is acting as a director for the company. Sir, what will happen after 3 years? He has to vacate the office. Whether members will reappoint the same person or not depends upon the behavior of the members. You can't decide. Okay. Next, AOA requirement. See, appointment must be authorized by articles of association. That means AOA should give the power to BOD to fill the casual vacancy. Sir, why this restriction is applicable only to public companies? Are very simple, ma. What is the minimum number or maximum number? Minimum number, maximum number criteria, you know it very well, no? Tell me the minimum number, maximum number limits of a public company. Minimum number is 7, maximum number is unlimited. There is no limit on maximum number for a public company according to Companies Act 2013. Say for example, 2 lakhs members are there in a public company. Is it possible? Highly possible, ma. So say for example, 2 lakhs members are there in public company. In the month of August, they held AGM and they appointed Mr. X as director to the board. They appointed so many persons. Out of that, Mr. X is also one of the person. After 1 month, X resigns due to his personal reasons, whatsoever reason it may be. Due to his personal reasons, X is taking exit out of the company. Now this kind of vacancy, we will call it as a casual vacancy. Listen. This kind of vacancy, we will call it as a casual vacancy. By default, actually what actually supposed to happen? Again, to fill this casual vacancy position, members has to gather. Board has to call a general meeting, and members, by conducting a general meeting, members has to fill up this vacancy. Members has to fill up this vacancy. But company is having 2 lakh members. Imagine how much administrative cost will incur for the company by simply serving letters to the 2 lakh people, 2 lakh addresses. Or, sir, nowadays no one is using letters right now, sir. But how much time, or you have to hire at least one database organization to send emails to the so-called 2 lakhs recipients. That means 2 lakhs members. Lot of procedural activities or procedural delays will happen to conduct one general meeting. Say for example, you invited 2 lakhs members for appointment of appointment of a director in place of casual vacancy. In order to fill that appointment, you are convening a general meeting. You are holding a general meeting. Out of 2 lakhs people, say for example, at least 5,000 people will attend to the general meeting. At least 5,000. I'm not talking about 2 lakhs out of 2 lakh will attend. 2 lakh people will not attend. Hardly 5,000 people or 2,000 to 5,000 people will definitely attend. Only 1,000 people attended. Say for example, 1,000 people attended for the general meeting. Okay, no problem. Now, what might be the cost of holding the meeting for 1,000 people? You have to hire one auditorium. Or, okay sir, auditorium cost also saved, sir. I am holding the general meeting in my registered office only, sir. In my registered office, one big auditorium is there. At least you have to provide food for them, na? 100 rupee plate meal cost, 100 rupee. 100 into 1000 people. 1 lakh you are spending. Forget about that 1 lakh. Okay, no problem. For few shareholders, you have to provide for significant shareholders. Shareholders who are holding 3% value, 4% value, 10% value, you have to provide to and fro charges, or you have to provide accommodation also. Why? Because say for example, one shareholder is there, that shareholder is holding 8% of the stake in your company. If you don't pamper these kind of 8%, 4%, 5% shareholders, what will happen? In your hard times, say for example, you have to pass an ordinary resolution. If you pamper properly these shareholders and all, they will support you in the voting, and they will the resolution will be passed. Otherwise, the resolution will get rejected. So you have to pamper these shareholders. At least you are not providing accommodation and you are not providing to and fro charges for all the shareholders. You have to provide accommodation and to and fro flight charges for members, right? Significant members, right? At least 2 to 3 lakhs will be spent on that to and fro accommodation and to and fro charges and accommodation charges. So how much you are spending? 4 lakh. And I am talking about worst case. I'm talking about worst case. Say for example, if 10,000 people attended, you have to spend 10 lakhs for their IT expenses only. Okay, so all these administration cost you are incurring just to appoint one director. And how much salary you are giving to director means 1 lakh per month. And for 8 months you are appointing, 8 months into 1 lakh, how much ma? 8 lakhs. So tell me, 4 lakhs you are spending. 4 lakhs you are spending for meeting in order to appoint a director, and the salary of the entire director for entire period is 8 lakhs. Is it worth to spend 4 lakhs to appoint one position or one director? Is not a good idea to hold separate general meeting just to fill casual vacancy. That is why what members will usually do, members will delegate the power of appointment to board of directors. That is why this point has been written like this. AOA should authorize board to fill the casual vacancy. And listen, this kind of mass members, large members will exist only in case of public company. What is the maximum number in case of private company? 200. Say for example 150 members are there, ma. You invited all the 150 members to fill the casual vacancy. Okay, 50 members will come. Is your company can't afford meals for 50 people? That is why casual vacancy refilling appointment rules are exclusively applicable for public companies only, and for private company, members has to refill. Why? Because lot of cost will not be incurred by private company by simply holding a general meeting. Why? Because mass people will be there in, mass people means large number of people will be there in public company, but that kind of large number of people will not be there in case of private company. And from financial point of view also, it is not financially viable for a public company to hold general meeting just to appoint one director. But it is financially viable for a private company to hold general meeting to appoint one director. That is why these rules are exclusively applicable for only public companies. And what these rules are saying, these rules are delegating the powers of appointment, power of appointment by shareholders to board of directors. Shareholders to board of directors. This is the point. So what we are discussing, casual vacancy. What is casual vacancy? Casual vacancy is a vacancy in the position of director who is originally appointed by the members in the general meeting. Each vacancy is not a casual vacancy. Why? Because there might be a chance that director who is appointed by board of directors may taking exit out of the company. That kind of vacancy will not be called as casual vacancy. Okay, this is what casual vacancy means. And Who has the authority to fill the casual vacancy by default? By default, actually, members has to fill. But it is not a good idea to call for general meeting just to fill one casual vacancy position. That is why by default the power will be delegated from shareholders to board of directors. Sir, how we know that power is delegated or not? Go and refer your AOA. If your AOA is giving authorization for you to appoint or to fill CV position, casual vacancy position, you will have the power to fill the casual vacancy position. Sir, our AOA is not saying anything, sir. Our AOA is silent, sir. Then you have to either modify AOA, either modify AOA. For modification of AOA also you have to conduct general meeting and pass special resolution. Modify AOA, or else call for general meeting, and by taking the approval from general meeting in by passing a resolution in the general meeting, appoint other director in case of casual vacancy position. This is the point. Are we clear? Next one, and the topic is not yet completed. Important points are there. What are the important points? First one, applies only to public companies. That is what I am saying from past few minutes. So what this bracket content is saying, not to private companies or OPC companies unless they adopted voluntary via AOA. Next one, casual vacancy can be filled only for directors appointed by shareholders in the general meeting. If a director was appointed by the board, that is additional director, alternate director, nominee director, then his vacancy cannot be filled under section 161(4). Just BOD will fill that vacancy as per AOA. So are we clear? How many points we have discussed today, ma? We have discussed 3 directors. First, alternate director. Next, additional director. Third one, casual vacancy director. So are these 3 points are clear? First one, tell me about alternative director. Alternative director is a person who gets appointed in the place of original director who is going out of India for a period of not less than 3 months. Not less than 3 months. 3 months kanna takku kaakudadu. Next, so alternative director will derive his power and position from the power and position of original director. If original director resigns, original director dies, original director came back to India, alternative director has to vacate the office. And alternative director appointment is automatic, or someone has to appointment on a specific note? Board has to appoint someone on a specific note. Alternative director appointment is not automatic. I am acting as alternative director to Mr. X. 1 month passed. He came back to India. I have to vacate the office. Okay, I vacated. After 1 month, he is again going back to abroad country. Or again he is going to a foreign country for a period of 5 months. Now I am not responsible as a alternative director. Why? Because my appointment already done and completed. If the board again appointed me as a alternative director specifically, then only I will be acting as alternative director. Do remember this point. Alternative director appointment is not automatic. Second one, additional director. Who is the additional director? Additional director is a person who is appointed by the board of directors to discharge the workload. Or simply, additional director is a person, additional director is a director who is appointed by the board of directors to the company. Simply we can conclude like this. Why the additional directors will be recruited to the company means it may be due to lot of reasons. In order to discharge the workload, in order to In some cases, in order to use the patent marks and use the trademarks and all, for that purpose also additional directors will be recruited. By offering lump sum as consideration, we may recruit additional directors also. There might be there are that kind of cases also. And third point is casual vacancy director. Casual vacancy director is a director. If a director who is appointed by the shareholders is going out of the company even before the expiry of his term, then that kind of vacancy will be called as casual vacancy. Each and every vacancy is not a simple. Resident director. Resident director, for each and every company this rule is applicable. For each and every company means for OPC, yes. Private company, yes. Public company, yes. Section 8 company, yes. Government company. For every company, this rule is there. And there is a tricky point in this resident director. Listen carefully. Resident director means every company must have at least one director who has stayed in India for at least 182 days in the financial year. The tricky point is even foreigners can also act as resident director. Resident director point is saying that the director should stay in India. Resident director is this provision is nowhere saying that the director should be an Indian citizen. Citizenship and place of stay both are completely different. So if a foreign member is staying in India from past 200 days in the financial year, that foreign member is also eligible to act as resident director to our company. Sir, how come a foreign member can act as a resident director, sir? Yes, the only condition is the director should stay 182 days or more in India. That is the only condition, not about citizenship, not about something else. This is the tricky point. If an MCQ or if any difficult question has been triggered by including a foreign person, 99% of the student will say that no, foreigner is not allowed to act as a resident director. 100% sure. Why? Because resident director provisions are restricting, or resident director provisions are saying about place of stay and period of stay. Place of stay and period of stay, not about citizenship. Very tricky point. I'm pretty much sure majority of the students will commit wrong answer if a tricky question has been framed in this resident director concept. Do you know minimum number, maximum number director restriction? Minimum number of directors and maximum number of directors rules, do you know? For OPC, tell me how many minimum directors for OPC? Kada, only one director, no? That one director should be resident director. That one director should be resident director. There is no option. Sir, I am an OPC, sir. I am having only one person, sir. That one person should be resident director. Sir, if he is a resident director, I wish to appoint MD, sir. Okay, appoint another person as MD, or else execute the same things with RD also. I mean, resident director. So, each and every company, whether you are a small scale company or large scale company, OPC, private company, public company, irrespective of anything, if you are a company, you must have one resident director on a mandatory basis. You must have one resident director. There is no exception to this rule. You must have one resident director. So, let's read these points. First one, every company must have at least one director who has stayed in India for at least 182 days in the financial year. Please don't ask me what is a financial year. Okay, 1st April to 31st March. Next, applies to, including, this applies to all companies, private, public, listed, unlisted, whatever the company it may be. Even a foreign national, that means he is holding citizenship in a foreign country, but he is staying in India, then he is allowed to act as resident director for a company. Why? Because the provisions are saying, or provisions are talking about period of stay and place of stay, not about citizenship. Next, new companies must comply within 6 months. This is a different thing. Why? Because after the incorporation of the, after the rules has been framed and made applicable to all companies, 6 months transition time will be given. The same 6 months time has been given for women director also. Women director provisions are latest amendments, right? Say for example, these rules are applicable from 1st April 2013. Before 1st April 2013, lot of companies are there, right? In order to comply, or in order to give proper time for the companies to comply with these so-called new rules and regulations, 6 months time will be given by the Companies Act for the transition. That means if you don't have any resident director as of now, Act is giving you 6 months time to appoint one director as a resident director. So that is the thing. So clear about resident director? This is the tricky point. What is this point? Even a foreign national can be a resident director if they meet stay requirement. If they meet stay requirement, that is the important point. Very important. Okay. 11th one, women director. Actually, from past 2 attempts, they are continuously asking one MCQ on women director, but nobody knows whether women director concept will be asked for December 2025 or June 2026, or no one knows. But women director concept is continuously being asked by the examiner by one or other way, either in short note or in a what we call MCQ. What is the relevance of women director? Very simple, women director is mandatory for every listed company, and for unlisted public company, which is having paid up share capital of 100 crore or more, or turnover 300 crore or more, for those kind of companies also, having one woman director is mandatory. Law is saying only that you must have one woman representation in your board. That is the only thing. Whether she is an independent director, executive director, non-executive director, any other director, doesn't care. Okay, just have one woman in your board, that's it. Okay, so for listed company, mandatorily applicable. You must have one woman director in your board, irrespective of your turnover and thresholds, paid up share capital and all. For unlisted, for private company, no need. Sir, I will maintain women director, sir. It is your headache, no problem. Sir, for unlisted public companies, thresholds needs to be verified. Please verify the thresholds. If you satisfy any of the thresholds, either you may satisfy paid up share capital threshold, or you may satisfy turnover threshold. If you satisfy any of the threshold, sir, I satisfied both thresholds, sir. Okay, no problem. If you satisfy any of the threshold, monetary thresholds, you are supposed to appoint, or you are supposed to maintain one woman director in your board. Sir, what are those thresholds? Paid up share capital 100 crore or more. Turnover 300 crore or more. If the company satisfy any of the mentioned conditions or met with any of the mentioned thresholds, the company has to maintain one woman in their board. In which position they will maintain? No hard and fast rule. Independent, dependent, executive, non-executive, MD, KMP, whatever it may be. So, listen, mandatory for every listed company, every public company having paid up share capital of 100 crore or more, turnover 300 crore or more. Points must be a woman. That is the only requirement. She must be a woman. Next, no specific qualification beyond general director qualifications. Sir, what are general director qualifications? I'll tell you at a later point of time. After 1 or 2 days, we are going to learn qualifications and disqualifications of director, which is very, very important. Actually, all these days we are learning basics only. All these points are not that much significant from examination point of view. Directors and KMP points, 100 out of 100 percentage. Directors and KMP, board meetings and procedures, this weightage in examination paper is going to be very huge. In June 2025 attempt only, they neglected directors and KMP point. Directors and KMP chapter. In that chapter only, in that attempt only, somewhat injustice happened to directors and KMP chapter. Sir, what kind of injustice happened? No theoretical question directly asked in the examination, but straight away first 5 questions, first 5 MCQs are from directors and KMP only. 5 twos are how much? Again, there is a representation, no? But many people will say that June 2025 exam is very tough. There is no question from directors and KMP. Okay, then no question means there is a MCQ, na? Straight away first 5 MCQs are case based MCQs from directors and KMP only. 5 twos are 10 marks straight away. 10 marks. Answering MCQs is way easier than answering theoretical question. Time will be saved and guaranteed marks will be there. You attempt 7 marks question, there is no guarantee that you are going to get 3 marks or 4 marks or 5 or 6 or 7. No one knows. But MCQs are not like that. If you know the concept very well, straight away 10 marks is in your pocket. Okay, so you may refer any previous examination paper held under syllabus 2022. There is no question paper without directors and KMP or board meetings and procedures. Having significance means not asking 1 MCQ or 2 MCQ or 1 question. No. In one attempt, around 40 marks asked from these 2 chapters. 40 marks. If you don't know, tomorrow I'll show you the examination paper also. Not only 40, if I'm not wrong, 46 marks. From these 2 chapters only. Directors and KMP, board meetings and procedure, 46 marks. Okay, so that is the significance of directors chapter. Actually, we are nurturing the basics only. What are the topics we have considered? We have completed types of directors and minimum number, maximum number, role of directors, definition of director. Okay, somewhat relevant for your understanding purpose. But these topics are not that much significant from examination point of view. Okay, somewhat women director, they are continuously asking for an MCQ or a short note basis. That is a different thing. But what are the topics which we are going to learn in coming days are very, very, very important. I have already shared the soft copy in your Telegram, no? Go and refer. Lot of concepts are there. Powers of directors, duties of directors, qualification, disqualification, appointment, reappointment, remuneration. That is very, very important. Remuneration, they are continuously testing the students' knowledge from remuneration point of view. Recently also one 7 marks question has been asked to determine the remuneration payable to determination of managerial remuneration. 7 marks question. These points are very, very, very important. So coming days topics are very important. Plan accordingly. Okay. The next one. So this is woman director. She no space. Qualifications point of view, we deviated. I just said that in coming days we are going to learn qualifications of director and disqualifications of director. That is the point. Okay, next one. The appointment should be made within 6 months of falling under the criteria. That is the transition time. I have already told about resident director. No. Why? Because these rules are new rules. Now, last but not least, she can be executive, non-executive or independent. She can be executive, non-executive or independent, whatever it may be. Okay, so women director. So tell me, for what kind of companies appointment of women director is mandatory? If you are a listed company, you have to maintain women director on a mandatory basis. If you are an unlisted public company, you have to check the thresholds. What kind of thresholds are there? 2 thresholds are there. 1, paid up share capital. 2, turnover. Paid up share capital how much? 100 crore. Turnover 300 crore or more. If you satisfy any of the condition, both the conditions should be satisfied. If you satisfy any of the condition, you have to maintain women director in your board. Okay. So by discussing SSD, we'll conclude this session. So today we discussed how many points, ma? Alternate director, additional director, casual vacancy director, resident director, women director. Previously, we have completed the discussion relating to executive director, non-executive director, managing director, whole-time director, independent director, nominee director also. 6 points we have already completed in the previous session, and alternate, additional, casual vacancy, resident director, women director we have completed in this session. If we complete SSD, total classification relating to directors will be completed. Only SSD is pending. Small shareholders director. Small shareholders director. Very simple thing. Who is a small shareholder? A shareholder who is holding shares worth of 20,000 or below. The 20,000 means market value or nominal value? Nominal value. Nominal value means face value. Nominal value means what value? You should not consider market value, ma. No, I'm not talking about market value. Market value may be way back higher than the face value. Definition is talking about only face value. That is nominal value only. Sir, I'm holding 1,000 shares in Infosys, sir. I'm holding 1,000 shares in Infosys. Say for example, 1,000 face value, hardly it is 1 rupee or 10 rupee, not more than that. 10 rupee. 1,000 into 10, how much, ma? 10,000. Now I'll be classified in the category of SS. Small shareholder. Small shareholder. 1,000 shares means, do you know the current market value? I think it is around 1600 or 1900, somewhere it is there. I don't know the exact figure. 1600 into 1,000, how much, ma? 16 lakhs, huh? Obviously 16 lakhs. So I am having assets worth of 16 lakhs, but still I'll be called with the name of small shareholder. Okay, don't compare or don't determine the value according to market. Always consider nominal value, that is face value. If a person is holding shares worth of 20,000 or below, 20,000 or below, that kind of person or that kind of shareholder will be classified as small shareholder. Small shareholder. Okay, sir, small shareholder definition understood. Then what is the relevance with related to this concept? Yes, listen carefully. If small shareholders decided that our voice is that our directors are not paying that much attention to our suggestions, our voice is going unheard, our representation should be there in the board, then small shareholders should make an application to the company saying that we need our representative in the board. He has to protect our interests. Whatever the issues we wish to escalate, we are going to escalate the issue through SSD, small shareholder director. So if small shareholders collectively, sir, okay, very good, we are all small shareholders only. We are all in a same feeling that we are getting our opinions or our suggestions or whatever the voice or whatever the issues we are raising, directors are not paying that much attention to the issues escalating by us. Then we collectively take a decision and will give representation to the board saying that we need a representative in the board of the company. That person is there to protect our interests. Sir, how many people should give representation to the company, sir? If one person or two persons or three persons go and ask, a company will entertain. No. At least how many members should represent the company? 1,000 small shareholders or 1/10 of the total strength of shareholders, whichever is lower. Say for example, one public company is there. In that public company, 1,50,000 members are there. How many members? 1,50,000 members are there. Total strength. 10% of the total strength, how much ma? 15,000. So we should compare 15,000 or 1,000, whichever is lower. Which is lower? 1,000 is lower. If 1,000 small shareholders go and make representation to the board of directors of the existing company, saying that we need a representative in your board, they have to give a formal representation. How many members are asking? What are their names? How much is their shareholding? Do they really qualify in the category of small shareholders or not? That is why they have to give their DP IDs also. Depository participant IDs will be there. No, they have to give the DP IDs also. Why? Because company may, in back end, company may go and cross check also whether this guy will become a small shareholder or not. If they give proper representation, then company must have one SSD in their board. Company must have one SSD. SSD means small shareholder director in their board. This is the point. Is it clear? Say for example, company is having 5,000 members. Company is having how many members ma? 5,000 members. Now, tell me the classification. 10% of 5,000 means 500. 500 or 1,000, whichever is lower. Which is lower? So how many members should give representation to the board? 500. At least 500 small shareholders should go and give a formal representation to the existing BOD, saying that we need our representative in this board. You are not paying that much attention to the issues raised by us. Our voice is going unheard by you. That is why we need our representative in the board. Like that, they have to give the representation, and after the representation, company will appoint one director as SSD. And there is a restriction. A person who is going to act as SSD can't act as SSD for more than 2 companies. That means a person can't act as small shareholder directors in 2 companies maximum. That means, say for example, I am acting as small shareholders in small shareholder director in X Limited company. Y Limited shareholders also suggested me and proposed my profile to appoint as SSD for Y Limited company also. Yes, Y Limited also appointed me as a SSD, small shareholder director. Now, is it possible for me to act as SSD for third company also? No. At a time, a person can't be acting as SSD for more than 2 companies. That means only 2 companies allowed. Beyond 2 companies, you are not allowed to hold SSD directorship. At a time, how many directorships you can hold? SSD directorships I'm talking about, not regular directorships. Regular directorships, I'll tell you at a later point of time. 20 directorships you can accept. Out of the 10 must be public companies. Max 10 public companies. Max 10 public companies. Okay. So with related to SSD, maximum how many? Maximum 2 directorships are allowed. Not beyond that. Not beyond that. Ma, tell me, what is the job role of SSD? To protect the interest of small shareholder director. Listen. Say for example, you all are small shareholders. I'm one of the director, not SSD. I'm one of the director in your company. Now, in rotation process, I'm losing my job. I'm going out of the company. Why? Because rotation rules, you might have some idea, right? So, few people will go out of the company, few people will join the company. It is a regular process. In rotation, shareholders didn't elected me as a director for the coming year. I'm losing my job. Okay, very good. In order to secure my job, I motivated all of you to select me as a small shareholder director and give representation to the company. If person like me elected as a small shareholder director, is there any guarantee that I am going to protect your interests? My ultimate attention or my ultimate concentration is to secure my job only, not to protect your interests. That is why person who is going out of the company or director who is retiring out of the company is not allowed to act as a small shareholder director. Why? Because if a person is going out of the company, employment dynamics will be gathered, and that kind of person, there is no guarantee that that kind of person will protect the interest of small shareholder director. Yesterday we learned about independent director, right? Independent director, everybody is qualified, huh? No, he should not be having any sort of pecuniary relation from past 2 years or employment or ex-employment from past 3 years, like that. Few conditions we have studied, right? Like that. This, as for this SSD position also, there are certain rules and regulations. Then only you are qualified to act as SSD. Listen, we'll read this topic and we'll end this session. So, who is a small shareholder? I have already told you. A small shareholder is a shareholder holding shares of nominal value 20,000 or less. What value? Market value అని ఉందా అక్కడ? Only nominal value, not market value. Nominal value means face value. Next, applicability. Appointment of small shareholder director is mandatory in case of listed company if don't study few till that point only. Why? Because for a listed company also, having SSD is not mandatory. If the same representation has been received by the members, that means demand should be started from members, not by company. Even though you are a listed company, there is no hard and fast rule that you have to maintain SSD. You have to maintain SSD only if 1,000 small shareholders or 1/10 of the total number of shareholders, whichever is lower, give a notice to the company. Notice means formal representation. Sir, we are in a feeling that our voice is going unheard. We need our representative in the board. By whatever reason, they have to give a formal representation to the company saying that we need our representative in your board. For that purpose, they have to give a representation. Listen, voluntary for any company if it chooses to appoint such a director. Say for example, your company is a very good company. Even though you didn't made any representation to the company, in order to protect your interests, company is voluntarily appointing a person as a small shareholder director. Is it a crime? Law is saying that, Are Babu, there is no mandatory rule on your part to maintain SSD. No, sir, I'll maintain. It is your headache. Go and maintain. So, as per rules, there is no necessity in your part to maintain SSD if there is no demand from members. Sir, our members are not asking to maintain SSD, sir. Then keep quiet. Sir, I'll maintain SSD, sir. Okay, go ahead. As per rules, there is no obligation. Unless and until your members are not making proper representation. If your members made proper representation, that is proper representation, not any representation. Proper representation means members you have to consider 1,000 or 1/10 of the total strength, whichever is lower, then only it will be called as a proper representation. Okay, next one. How SSD will be appointed? A notice must be given by the eligible small shareholders. Notice must be given by small shareholders. Eligible small notice must be given by shareholders. Eligible small shareholders. Eligible small shareholders means those shareholders who are holding 20,000 or less shares, along with a declaration from the proposed person that he meets the eligibility criteria. The company shall appoint SSD in a general meeting through ordinary resolution. The notice must contain name, address, number of shares held, folio number, DPID, signature of the shareholders proposing the person. Sir, we need our representative, and our representative should be so and so person, Mr. X or Mr. Y or Mr. Z, like that. Next, eligibility criteria. That person not be disqualified under section 164. I'll tell you what is 164 and all. I'll tell you later point of time. Next, not hold directorship in more than 2 companies where he is an SSD. Maximum number of directorship limit is different, that is 20. This is talking about SSD directorship. SSD directorship more than 2 is not allowed. Next, not be a retiring director under section 152. Why? Because there is no guarantee that that retiring director is going to protect your interest. That retiring director always focused to protect his employment only, not to protect your interest. So that is why that person should not be appointed, not be a person, not be associated with the company or its promoters in any professional capacity in the last 3 years. Why? If he is an associated party, again there is no guarantee that he is going to represent your interests. That is why no. Tenure maximum 3 years ma. After 3 years no appointment should be done, no reappointment. After 3 years again cooling period will be there. The cooling period is again 3 years. So it is very simple to remember the tenure and cooling period of SSD. Why? Because tenure is 3 years, cooling period is also 3 years. In case of ID, tenure 5 years, reappointment another 5 years, cooling period 3 years. 5 plus 5. After 10 years, 3 years cooling period will be there. For SSD also, same cooling period will be there, 3 years. But like ID, there is no concept of reappointment in case of small shareholder director. Go. Can be appointed for a maximum period of 3 years, but not eligible for reappointment immediately after the completion of tenure. After 3 years, the same person can be reappointed only after a cooling period. The cooling period is 3 years. Role and all, SSD is treated at par with directors. At par ante equal with directors. He can be independent director if he meets the criteria. Not required to be elected by rotation. Why? Because period will be fixed at the time of appointment only, for 1 year or 2 years or 3 years. Period will be fixed in your appointment letter. No need to go by rotation and all. Okay. Summary table we will discuss at a later point of time. Tomorrow we will discuss. So summary is nothing but after summary I am going to discuss qualifications and disqualification. Okay. Summary, anyway we will revise tomorrow about all the directors na. At that time summary will be used for you. Simple ma. Executive director, full-time employee involved in daily management. Non-executive, part-time advisory role. Managing director entrusted with substantial powers. Whole-time director devotes whole time to the company affairs. That means full-time employee. Independent director, independent of company and promoters. Nominee director, nominated by institutions or government. Alternate director substitutes for an absent director. That absence must be greater than or equal to 3 months. Absence I am talking about. Additional director appointed by board and the tenure will be there until next AGM. Casual vacancy director appointed to fill the mid-term vacancy. Resident director stays greater than or equal to 182 days in India in financial year. Even foreigners also allowed to appoint. Next, women director mandatory for certain companies. What are those certain companies? Listed company, unlisted public company, 2 thresholds. Paid up share capital 100 crore or more, turnover 300 crore or more. Both the condition need to be satisfied. Any of the condition. Simple. With this, we have successfully completed the classification of directors. Okay. Tomorrow once again we will revise and will start a fresh topic. Qualifications and disqualification. Disqualification is 5-star rated from examination point of view. Disqualification is most important from examination point of view. 164 section, 164.1, 164.2, 164.3. Any doubt, ma? Up. Get up. Any doubt? No need to give any approval. What kind of approval they should give? Even before appointment in AOA they should give. Say for example, casual vacancy రాకముందు, అరే బాబు మేము అపాయింట్ చేస్తున్నాం కదా డైరెక్టర్స్ని, వీళ్ళల్లో ఎవరైనా మనసు మార్చుకుని వెళ్ళిపోతే, క్యాజువల్ వేకెన్సీ వస్తే మమ్మల్ని అడగొద్దు, మీరు ప్రొసీడ్ అకార్డింగ్ టు యువర్ ఓన్ డైరెక్షన్స్ అని షేర్ హోల్డర్స్ ఏఓఏలో ఆథరైజ్ చేస్తే అప్పుడు ఉంటుంది, అంతేగాని బోర్డ్ ఆఫ్ డైరెక్టర్స్ ఫస్ట్ అపాయింట్ చేసేసి తర్వాత మళ్ళీ అప్రూవల్ అట్లా ఉండదు. ఓకే. అండ్ మీకు నేను చెప్పినట్టున్నాను ఆల్రెడీ ఒకసారి, క్లాస్ అయిపోయినాక మీరు ఏ డౌట్స్ అయినా అడగొచ్చు అమ్మా, క్లాస్ మధ్యలో మాట్లాడొద్దు. ఓకేనా? దట్ ఈస్ ఇండీసెంట్ అండ్ ఇట్ ఈస్ ఎ సింబల్ ఆఫ్ ఇండిసిప్లిన్. ఓకే. నిన్న రాలేదా నువ్వు? కూర్చోవా? వెరీ గుడ్, కూర్చోమ్మా. ఎనీ న్యూ కమర్స్ ఎవరు లేరా? నువ్వమ్మా, నేను రాలేదా నువ్వు? ఏం పేరమ్మా? కూర్చో. సుమంత్. ఎప్పుడైందమ్మా ఇంటర్? సిఎంఏ ఇంటర్. ఓకే, ఎక్కడమ్మా కోచింగ్? ఓకే, వెరీ గుడ్. సో this is all about today's session. So what is our today's session, ma? Today's session is completely dedicated to the classification of directors, and we have discussed the various directors qualities and tenures and qualifications and disqualification. We discussed disqualification 164 is very important. 164.1, 164.2, 164.3. Tomorrow I'll discuss about qualifications and disqualifications. Tomorrow is Saturday, right? Or no? Thank you. Thanks for the confirmation. Okay, right. Let's discuss tomorrow.